Welcome back. We're continuing with the Kellen Winslow Jr. case as Jane Doe after Jane Doe is testifying. I want to now welcome our new guest, David P. Shapiro. David, how are you doing today?
Not bad, Brian. How are you?
Great. Now, David, we're going to start diving into the Jane Does, but during the break, I think you've answered the question that's been plaguing me for the longest time. Now, Jane Doe is the alleged victim who was saying she was raped when she was 17, and we keep asking, where's the statutory rape case? Can you explain?
Yeah, sure, Brian. What's going on here is this is an allegation when Winslow himself was just barely over 18. He was in college at the University of Miami. It's alleged that Jane Doe was just under 18 at that time. So legally speaking, could they have pursued, just based on that, a charge of statutory rape? Quite possibly. But the issue is, since Winslow was barely over 18 himself, the best they could get is a misdemeanor. It would not require registration as a sex offender pursuant to Penal Code Section 290 here in California. So it's certainly small potatoes in the grand scheme of things. And I think that's why they're going ahead with the actual forcible rape charge, as well as some issues due to the 16, 17 years in between the alleged act and the actual allegation.
Oh, thank you so much for answering that plaguing question. Let's actually listen to some of the testimony from Jane Doe number 4 when she took the stand. So again, we're not able to show Jane Doe number 4's face or any of the Jane Does, but there she is testifying as to the incident as she perceives it. David, as we're listening to it, she's painting a pretty clear picture of what happened. I can't imagine the defense is in a good place at this point of the trial.
Well, Brian, here's the thing. I mean, the defense is certainly concerned and should be concerned with the testimony of Jane Doe 4, what they heard earlier in the week, because in many instances, she's testifying consistently, almost to a T, with what we see as defense attorneys and what prosecutors see and what judges see and what juries see when there are situations known as delayed disclosures. Here, this was an incident that occurred back in 2003, and although she didn't report anything to law enforcement for a good 16 years or so, what we saw and what we heard were some stagnated, basically, disclosures. At first, she told her friend, I think that night or in the coming days. Then she told a live-in boyfriend. Then she told her husband. Then she told law enforcement. So from a defense attorney's perspective, they should certainly be concerned about that. They should certainly be concerned about the raw emotion that this lady still feels to this day, being in the same room as Mr. Winslow, recounting the incident with Mr. Winslow. On the flip side, though, the defense should be encouraged by a lot of inconsistencies within Jane Doe number 4's testimony. Most notably, where the act allegedly occurred. I think there was a prior statement that it occurred inside a vehicle as opposed to inside a bedroom. So there are certainly things to work with from a defense perspective. But as far as the Jane Does go, it's my opinion that she was the most compelling, certainly when it comes to the more serious charges alleged by Jane Doe 1, 2, and 4.
Yeah, and I agree with you. It kind of cuts both ways, and I think there's always a trouble of getting a story from a Jane Doe, I guess, for the prosecutor, and trying to recount something that is obviously embedded in her brain because of the trauma or the severity of the act, but also there's going to be details that are missing. So is that just par for the course for the prosecution, and they've kind of just got to go through it and say, hey, she's going to mix up some things, she's going to mess up some things, but I mean, how much of 2003 do you remember?
Well, not a lot. I mean, I was 22 in college, so not a lot. But what I can tell you is that I'm a little bit surprised, quite frankly, that the prosecution did not put on some sort of testimony to explain why people would not disclose right away, to explain how the memory works, how people may not remember what a jury may view as important details, what the defense attorneys may argue as important details. Hey, if this really happened the way you say it did, how do you not remember that? How are you giving inconsistent statements about this occurring in a car versus occurring in a bedroom? All of those things. So quite frankly, I was a little surprised that there wasn't that testimony to sort of explain some of those inconsistencies. Certainly the DA could argue it in closing, but I would be, if I was a defense attorney, I would expect to see something along the lines of more medical testimony about that.
Yeah, it's going to be interesting to see how that plays out as the defense puts on their case. So, David, there we have it. The Jane Doe number 4 again recounting the incident. For me at least, when I'm a defense attorney, sometimes the direct is always the most harrowing because although my client's presumed innocent, it's sometimes an uphill battle where they hear the alleged victim testify, and then now you've got to get up there and somehow try to change the narrative and show the inconsistencies. But this seems like quite a steep hill to climb.
Yeah, Brian, it certainly can be, especially when you have these delayed disclosure cases, because you're asking basically the defense to go to their client and say, hey, okay, first off, assuming this even happened, this was something that happened 16 years ago. So what, if anything, Kellen Winslow II remembers about this is an uphill battle, like you said. What, if anything, witnesses who may have been there or may have witnessed both Kellen Winslow's behavior and Jane Doe's 4 behavior before, during, and after this incident sometimes is an uphill battle. It's difficult to find all these people. It's difficult to make them go back in that time and remember all that stuff. So sometimes these types of accusations, when there's not a lot of whole recency there, when we're talking 16, 17 years back, are actually more of an uphill battle, as you stated, and more challenging for the defense than more recent accusations that we're hearing from the other Jane Does.
Yeah, and we're going to hear it in a moment, but sometimes I think about the cross-examination, it's going to be like, well, it's kind of old and stale. Like, this is 16 years ago. How much is she going to really know? How much is my cross-examination going to really point out the inconsistencies, or merely just show that this happened 16 years ago? To your point, you said that you were 22 back in 2003. I mean, I was 15 at the time. I can barely remember the classes that I took or the teachers that I had. And now you want my lawyer to recount the exact incident that happened back then? It's kind of like you're walking without a roadmap.
Yeah, without question. I think the defense did an effective job to a degree in bringing out the inconsistencies, but also talking about how the fact that through Jane Doe's own admission, Jane Doe 4, that she engaged in consensual sex with Kellen Winslow roughly 2 weeks prior to the alleged rape. So I think they were effective in pointing that out there. And then certainly you could make the argument in closing about all the inconsistencies. But sometimes when you harp on so many inconsistencies over and over and over again on cross-examination, you may lose credibility with the jury, you may lose likability with the jury. Sometimes it's more effective to note them subtly, sit down, and then argue it in closing argument as well.
Fully agree. And let's actually look and see what the defense attorneys did, or what the attorneys did in cross-examination. So there you have the defense attorney cross-examining Jane Doe number 4. And David, I think I'm understanding where the defense attorney is getting at here, where they're trying to lay the groundwork of, this is a party, you were drinking, you were having a good time. Maybe that's an effect on her perception of that at that time, or an effect on her memory today. And it seems to have nothing to do with Mr. Winslow.
That's correct, Brian. I think what they're doing is they're trying to focus more on the fact that because she was so intoxicated, that she doesn't have the clearest memory of what did or didn't happen. And over the course of the past 16 some odd years, that her memory could have been sculpted by what she believed, what she might have heard. And she has this sort of break from reality as to what did or didn't happen that night at that house party. Problem is with that is you can't go too far with it, because if you want to say, well, she was so intoxicated, she was so out of it, she was so incapable of understanding what's going on, then if I'm the prosecutor, I'm turning around and saying, well, she's incapable of consenting, which is one of the elements and one of the crimes that he's going to be charged with, and that the jury is going to consider whether or not the case has been proven beyond a reasonable doubt against him. And that's what makes these whole, where someone has the inability to consent on these sexual assault cases so difficult, because in one regard, someone being so far out of it, someone being so intoxicated is usually a positive as it relates to their memory, but it could also cast doubt on whether or not, in this case, Winslow knew that she was even capable of consenting in the first place.
Yeah, and it's going to be interesting to how they draw that line, because even if we take the law out of it for a second, you just think, I mean, I've had a drink, you probably had a drink. What is the line where I know what I'm doing, I can consent to what I'm doing, but my memory is going to be a little fuzzy? I think that raises a lot of questions for your people themselves to try to reflect and be like, I don't know what that is for me, and also to gauge for other people. David, have you ever had this in your practice, maybe not specifically to these cases, where you have to toe the line of kind of, or not the line, but kind of be on a fence and be like, I can't go too far this way and I can't go too far this way? How do you explain that to the jury in a way that's real and authentic?
Without question, Brian. The firm actually just got hired on a case this week, without getting into the specifics of it, obviously, very similarly situated here, where the initial intoxication of the alleged victim is really good for the defense because there's big time memory issues. There's a lot of empty spaces as far as details that they don't recall. But at the same time, there's a big problem when it comes time to well, then my client presumably should have known that this individual was incapable of providing consent. So it is extremely difficult from a defense perspective not to cross that fence, because once you go too far, then basically what you're saying is, well, it wasn't forcible rape, but it was rape of someone who was incapable of consenting, of an unconscious person. So, it's sort of when you go too hard in defense of one of these charges, a basic rape by force charge, you're sort of, in a way, strengthening the rape of an unconscious person charge. So it's a very difficult line, and it's something that certainly needs to be, and I believe was addressed in this case during jury selection, to make sure that you have, as much as possible, the best type of jurors for these cases who will be able to differentiate between the two, and will be able to put, one aside when they're assessing the guilt or the innocence of the other.
Yeah, they're towing the line pretty well. Drunk, tipsy, explaining the difference in how her faculties might have been when this alleged incident occurred. Does that help the defense's theory as they go forward?
Well, Brian, it certainly helps their theory as it relates to rape of an unconscious person, because what the defense attorney, in this case Mark Carlos, was getting at was that Jane Doe number 4 was buzzed, and differentiating between buzzed and drunk. Drunk could be more of a problem when it comes to rape of an unconscious person. Buzzed would not be that much of a problem when it comes to rape of an unconscious person. So in that clip, they're providing the groundwork for a good argument for that charge. The problem that they're going to have is, yes, that may get them an acquittal as it relates to rape of an unconscious person, but as Jane Doe testified to, she comes to it, assuming that's true, in the middle of this encounter. So everything before then could presumably be excused under law if she was not objectively showing signs that she was so out of it. The problem is, based on her own testimony, if it's believed by this jury, is that when she says, Winslow flips me over and continues to penetrate me, and I say, stop, 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 right there, that's forcible rape, whether she's drunk, whether she's buzzed, whether she's sober for 10 minutes or 30 years. So that's a problem they have, and that's sort of what we were touching upon earlier, that you go all in segments on one charge, and it could cost you at the expense of another. And that's what makes these cases, particularly when the district attorney charges them interchangeably, meaning charges rape, forcible rape, and then rape of an unconscious person, makes them so difficult to defend against.
Yeah, it's going to be an interesting case. And again, we keep coming back to this on the show here. If it was one defendant, maybe I can see a road to not guilty or an acquittal as it is to this one alleged victim. But David, my question is to you now is, when we take this one alleged victim and we kind of superimpose it to all the rest, are we just kind of spinning our wheels and saying, well, maybe a little bit of reasonable doubt here, or maybe a little bit of reasonable doubt here, but when the jury starts to consider all of these cases, are they just going to forget the minutia and the small details and just say, you know what, these are all too similar, he definitely did it?
Well, that's certainly the fear of the defense, Brian, because quite frankly, I think out of the 5 Jane Does, I'm not sure if 3 or 4 of them would have been charged independently, meaning if there was no other alleged wrongdoing here with other Jane Does coming forward. I personally don't think they would have charged, and they weren't going down that path with Jane Doe number 1 until they found out about Jane Doe number 2. I don't think Jane Doe number 3 would have been charged the indecent exposure in and of itself unless they believe they had him on these other counts. I don't think Jane Doe 4 would have been charged independently unless they believe they had him on all these other counts. And here in California, the jury can certainly consider evidence of these other acts to sort of bolster the other witnesses' claims. And that's a big concern on these sexual assault cases from the defense perspective, is that tried individually, the district attorney may not hit reasonable doubt on any of these charges, on any of them. Tried together, he may wind up getting convicted of everything. So that's a problem with the state of the law from the defense perspective, and certainly a realistic concern for Winslow's defense team, and particularly Winslow and his loved ones to have.
It's going to be interesting to see how the defense attorney presents that to the jury. Maybe they present it just as you did, that if this was done individually, we saw and we see problems with each individual case. Don't be, hoodwinked or allow the prosecution to kind of paint with a broad brush. But again, we'll see what the defense does. We're going to come back with this and more cases after the break.
Have Have you been seriously hurt in an accident? Think it's easy to sue and get a major settlement? You should know how long a lawsuit takes. Years. That's why you need the right lawyer. I'm Michelle Merman. We've represented the wrongfully injured for 40 years, winning over $1 billion for them. I know what you're going through. We can help you through this difficult process to get the resolution you deserve. Call 1-800-HURT-NOW, because justice is no accident with the right lawyer.
All right, crew, let's get started. Sure.
Don't ignore the law. You must call 811 at least 2 to 3 days before any digging project so you can avoid hitting our essential buried utilities. For digging projects big or small, make the call to 811.
How I define making? In the broadest possible terms, it is making something extant in the world that didn't exist. Everybody who's ever made anything is bringing something into fruition for a reason, and that act in and of itself makes us stewards of our culture. It's something that we're talking about. It's a response. Actually, it's telling a story. That's really what it is. And I include everything that could be made: painting, sculpture, welding, all of that.
Yellow is positive.
When a kid gets their hands on the world and learns that they can make their fantasy play, that they can make their reality, that's power. And as far as I'm concerned, everyone should feel that kind of power. There we go. If there's something that interests you to bring into the world, that's fantastic. Go figure out how to do it. Go tell your own story. There it is. And so I want to know why you make. Let's go.
Share your own Why I Make story today. Visit whyimake.org.
We believe in patriotism. We believe in our nation's youth. We believe veterans earn their benefits through their service to our nation. We believe in a strong national security. We believe in our country. For 100 years, veterans have been impacting our nation through the American Legion, and we believe it makes a difference. If you believe, learn more at legion.org/webelieve.
Anyone can fall victim to moving fraud. Know your rights and responsibilities.
We had really signed off on a price, and that was about it.
Without a signed written estimate, movers may try to charge more.
They were charging us now $2,000 instead of the agreed upon $900.
And may hold your items hostage until you pay.
Not only had they roughly handled or mishandled, it seemed like they had purposely destroyed things.
Visit protectyourmove.gov to download a free moving fraud prevention guide. Search for registered movers and view their complaint histories. Move with confidence.
Welcome back. We're continuing with the Kellen Winslow Jr. case, again recounting the various Jane Does who testified in this case. Now we're actually going to go to the sergeant who interviewed Jane Doe number 4 and what he had to say when he took the stand.
So Jane Doe number 4 contacted you, and what did she say? Did she have something to report?
Yes, she said that she had been sexually assaulted by Kellen Winslow Jr. when she was in high school.
So at that point, of course, you're very interested, right?
Correct.
And you inquired into what happened?
Yes.
What did she tell you happened?
She told me that she was going to high school in Escondido at another high school and had a friend who went to Scripps Ranch High School with Kellen Winslow Jr. and was a friend of his, and that Kellen Winslow Jr. picked her up to go with the intention to go to a house or a residence party.
Let me stop you right there. So she was specific in saying that Mr. Winslow drove his vehicle and picked her up?
I don't know that she mentioned it was his vehicle, but yes, that he picked her up.
Okay. And then what else did she explain to you?
She said that she was given a drink, I believe by Mr. Winslow.
Now let me stop you right there.
Yes, sir.
she was given this drink by Mr. Winslow in the car while they're driving?
She didn't specify.
But she did specify that she was given a drink by Mr. Winslow.
Yes.
She received a drink. Okay, what else did she tell you?
She told me that at some point during the car ride, she didn't remember anything. She believes she lost consciousness. And then she awoke either at this residence or a house, some building, and there were several males groping and digitally penetrating her. And at some point they all left, and that Kellen Winslow Jr. had intercourse, vaginal intercourse with her, unwanted vaginal intercourse, and that's the last thing she remembered.
So there's the testimony of Jane Doe going to the detective, or the sergeant, sorry, and telling her story and him testifying. We also have Jane Doe number 4's friend, who is what we call in New York at least an outcry witness, in what she recounts when Jane Doe number 4 spoke to her. Let's take a listen.
You guys started exchanging text messages about coming to court and that sort of thing. Was it you that said, we got to take Kellen down?
Yes.
Okay. Nothing further.
All right.
It was more so if I didn't want to just stand back and not do anything and let this happen to any other females or anybody else.
And
It felt like something had to have been done.
Oh, I'm sorry, wait,
Sorry.
hang on, let her finish her answer.
Sorry, I
Go
just felt
ahead
like
and finish your answer.
I just felt like something had to be done.
What do you mean when you say that something had to be done? Based upon what you remember with Jane Doe number 4 and what you knew at that time when you sent that message?
To speak up so it won't happen to anybody else.
Did you feel, based upon what happened to Jane Doe number 4, that you should have spoken up before?
I should have, yes.
Did you feel somewhat responsible for the fact that this happened to other people?
Somewhat, yes.
So there's an interesting juxtaposition of the sergeant who heard when Jane Doe number 4 outcried to her, and then again a friend who had heard the outcry much sooner, and a little bit of a twist there from the defense where saying, well, I'm out to get him, we got to get him. David, what do we make of this?
Well, a couple of things you can make out of it, Brian. First, what was really interesting was the fact that it was actually the defense who called the sergeant from the sheriff's department. So he was the first defense witness. And the reason why they put him on the stand was to automatically undermine the credibility of Jane Doe number 4, one of the more compelling Jane Doe witnesses against Mr. Winslow. And this was the sergeant who she spoke to first, so her first encounter with law enforcement in 2018, before she met with the district attorney's office, before she met with the district attorney investigator, before she testified under oath at a preliminary hearing. So I believe the inference the defense was getting at by calling this sergeant was that, hey, anything that she said differently after this initial call with the sergeant was sort of a way of her sculpting her testimony to blend in with the other Jane Does, whether at the direction of law enforcement, whether at the direction of the district attorney's office, or whether at the direction of the public at large. So I think it was a good intention there by calling that sergeant. I know, and I having listened to the testimony, I know that the cross-examination...
Absolutely agree. Absolutely agree with you there, David. Sorry to cut you off, but I'm going to sign you off, and as me as well. Make sure you stay tuned as Michael Bryan is here, the Law&Crime Channel Network, which continue with Gavel to Gavel coverage. Enjoy your weekend, everyone.